Heartbreak Kid, Shawn Michaels, WWE wrestling, but
Okay.
I'm a heartbreaker.
And what else?
Um,
You got
Baby mom's name, my child mother's name, my son's initials, my mother's name.
okay. So any of your tattoos gang related or anything like that?
No, sir. No gang related tattoos. Just a bunch of names and stuff like that.
All right. Just freedom of speech.
Yes.
Or freedom of expression.
Expression.
No different than Ms. Brown.
No different than anybody.
No different than your mom.
No.
All right. Okay. Let's talk about June of 2020. At some point, what your 2-year-old is there, right?
Yes, sir.
Prior to you getting into a confrontation with Miss Brown, tell the members of the jury what happened.
Prior to the altercation between me and Ms. Brown, the situation, I believe I heard physical altercations going on in the house, around the house.
And when you say physical altercation, are you referring to your mom and Miss Brown?
Yes.
All right. Then what happened?
Me and my son had woke up out our bed that night. I told him just go back to sleep. I'm going to check on the situation. Daddy, be right back. I went to the garage. I couldn't see my mom. I only seen Amber. I asked Amber. I said, "What's going on? And where's my mom?" Because there was so much ruckus going on. So I'm just really just like, "Where's my mom? You know, why is everything so loud?" But she proceeded to respond in an aggressive manner.
All right. When you said she proceeded to respond in an aggressive manner, were y'all arguing?
No, it was not.
Okay. When you say she proceeded to respond, what do you mean?
She told me we can't cuss on here, right? No.
If someone asks you,
Yeah, what did she say?
Okay,
What
she told me to take my fucking ass in the house.
Okay.
In an aggressive manner, though. But she said, "This is not my business to take your ass in the fucking house." That's what she said.
All right. And did you go in the house?
No, sir.
All right. You continue to
I really searched for my mom because this TV train is a seating area in between the two cars. So I didn't see my mom, but while I was walking towards her. In the midst of me walking towards her, my mother ends up coming outside.
And then what happened?
They get into an altercation, a verbal altercation.
Okay. And then what happened?
So the disagreements go on, and I guess Amber didn't like what my mother said, so she ended up grabbing a tray, and she throws it at me, hit me right outside the head with it.
All right. Well, and let me ask you, may I approach Judge?
you may.
You've heard us talking a lot about this tray, right?
Yes, sir.
I'm not gonna get it all over. Let me show you what's marked as State's Exhibit number 16. Does this appear to be the wood tray that she hit you in the head with?
Yes, sir.
And I'm saying here, right?
Yes, sir.
All right. And when she hit you in the head with the wooden tray, I mean, how'd that feel?
She really, I almost knocked me out. It really dazed me.
When you say it dazed you, I mean, she hit you directly in the head with that wooden tray?
Yeah, I didn't have any balance with it for dazing.
Okay. And did her aggression continue?
Yes, sir.
Well, tell me, after she hit you in the head with the tray, did she grab the tray and hit you, or did she throw the tray and hit you in the head?
No, she threw the tray. She didn't grab it and hit me. She threw the tray and hit me.
Okay, and it hit you in the head?
Yeah, just right in the head or something.
And does that daze you?
Yes, sir.
Does it shock
It shocked me a lot.
you? Did it hurt?
Yeah, it hurt.
Okay. So at some point, where is she when she hits you with the tray, if you recall?
In between the cars, but I really don't know too much because it happened so fast, but we was both in between the cars for sure.
At first?
Yes, at
And
first.
then, when she hit you with the tray, what happened?
After she hit me with the tray, me and her got into a fight.
Okay. And, I mean, when you say got to a fight, did y'all tussle what?
Well, we had a tussle, but since my mom was outside, it was probably maybe 15 seconds. It wasn't too long. We got into a tussle. My mother somehow just came between us and she broke up the fight.
Alright. And did you think it was over at that time?
I thought the situation was de-escalated, yes, sir.
Alright. In fact, did your mother turn and go back in the house?
My mother went in the house, yes. After she after she broke up the fight, she went in the house, yes.
Okay. But, after your mom went in the house, did y'all continue to quarrel?
We
But just tell them what happened once your mom went in the
Yeah,
house.
once my mom went in the house, we didn't continue to do much of anything. My mother went in the crib. I was basically like taking a small breather, but Amber still felt some type of way about something my mother said. And as I was walking in the house, I just heard something. So when I turned around, I seen she had a tray in.
Okay, and where were you at that time?
I'm right by the car, just right by the car, but I'm walking towards the door. Like I'm already leaving, I'm walking towards the door. So I'm finna go inside the house. I'm finna go inside there.
Alright, then what happens?
When she grabs the tray, I grabbed the closest thing to me. I feared my life. I grabbed the gun.
Alright, was the gun already in the garage?
Yes, sir.
And why did you grab the gun?
Because she already had grabbed the tray. She's already hit me in the head with it once, and I definitely didn't want to get hit in the head with it again.
Alright, were you planning to shoot her with the gun?
No, sir.
What did you want to do with the gun?
It was a scare tactic.
Did that scare tactic work?
Not at all.
In fact, did it make her even more upset?
It made it worse, yes, sir.
At some point, are you standing outside the garage or behind that car?
Yes.
Well, remember we saw the black, is that a Charger?
Yes, sir.
So is that where you're standing?
On the side, yes, sir.
And where is she at, if you recall?
I can't necessarily really remember, but she's coming towards me.
Okay. And then what happens?
When she comes towards me and I see her with a tray, I let off a warning shot.
What do you mean you let off the warning shot?
I shot towards the sky, sir.
Okay. And then what happens?
That didn't put any fear in her. I'm not gonna lie. It didn't put any fear in her. She ended up charging at me. When she charged me with the tray, I got scared and I turned around and I shot.
Did you think she was gonna hit you with the tray?
Yes.
When you say you shot, where did you shoot?
I don't know.
Why don't you know?
Because I didn't see it.
Why didn't you see?
Because I turned around. I
Why?
turned around and I shot.
I mean, show them how you turned. Why did you turn your face?
Because I thought she was finna hit me with the tray. I thought she was finna throw it at my head again. And daze me. Not really.
Were you concerned she's gonna hit you in your face with the tray tape?
Yes.
Is that why you turned
Yes.
when you shot?
Yes.
As far as what she did when you raised the gun, do you have any idea?
No, sir.
Because you weren't looking at her.
I didn't see. No, sir.
Okay. When you fired at her, were you trying to kill her?
No. Never.
Well, what were you trying to do?
I was really trying to back her off. But like I said, I just closed my eyes and turned around and shot, and I wouldn't.
How many times do you even know how many times you fired?
No, sir. I just squeezed.
Okay. Did you think you hit her?
No, not at all. Until I heard that she said she was shot.
Okay. Did you know where you had shot her?
No, sir.
Okay. After the shooting, does she drop the tray tape?
Yes.
All right. In reference to, well, once she drops the tray tape, is that why you stopped shooting?
I stopped shooting because I seen she was shot. And yes, when she drops the table, I definitely, everything was just a shock and happened so fast. I just wanted to save her, to be honest.
Or what do you mean you just wanted to save her?
When I found out she was shot, I just wanted to save her. I stopped everything. I grabbed my son, grabbed my mom's keys.
Did your mom come out?
Yes.
And what happened when your mom came out?
She was panicking. She was panicking, but she was catering to Amber. She was trying to make sure she was okay. I was more trying to get her to the hospital right now.
When you say you grabbed your keys, is that what you're talking about?
Yes, I grabbed her keys, yes, sir.
Why didn't y'all take her to the hospital immediately?
My mother did not take her to the hospital. She didn't want me to take her to the hospital because we didn't know where she was shot.
And she was afraid to move her?
Yes, she was afraid to move her, yes, sir.
Okay. At some point, you say you grabbed your son. Why did you grab your son?
I couldn't leave him there alone, and
What did you do with your son?
he was gonna have to come with us, and I ran across the street to go to the neighbor's house because I trusted him with my son. Nobody picked up, so unfortunately, he had to go through everything we went through that night.
Okay. At some point, we see you on the body cam, standing there with your shirt off, with your hands up.
Yes, sir.
Again, what time of morning is this?
Maybe 2 a.m., maybe 3 a.m. I can't remember. We were just asleep, so maybe 2 a.m., maybe 3 a.m., but I just know it was past 12.
Okay. So all the arguing you heard actually woke you and your son up?
Yes, sir.
2, 3 in the morning?
Yes.
All right. We see you with your hands up. And are you trying to explain to the police what happened?
Yes, sir.
All right. You remember at some point in the video you say stuff got physical.
Yes.
When you're saying stuff got physical, are you referring to her hitting you with that tray tape?
Yes, sir.
Okay. Are you referring to being afraid she's going to hit you with the tray tape?
Most definitely.
Did you intend to kill Miss Brown?
Never. Never. Still to this day. Never.
But you were shooting her in self-defense.
Yes.
Did you make it clear to the police that you felt you were acting in self-defense?
Yes, sir.
I just want to make sure I'm clear. You said you grabbed the gun because you thought it would scare her.
Yes.
Everything that you did that night, did you feel it was immediately necessary
Most definitely.
to protect yourself?
Yes.
Okay. You remember on the video, you were telling the police you had to protect your mom. What do you mean by that?
Because when I heard the physical altercation, I thought she was getting beat up.
But as far as shooting at her, that was to protect yourself.
Yes. Yes, sir.
You indicated that Ms. Brown was amped up. What do you mean by that?
She was very amped up. I've never seen her like this before. We never really been into altercations at all, so this was the first time for everything. I don't know what necessarily drove the anger. I don't know what the conversation was about before they got here, but she definitely was on 10 to 20 for sure.
Well, you heard your mom say she was upset about her daughter having to leave.
Yes.
Okay.
But super upset.
Okay. And did your son actually take over that room?
Yes. Yes, sir.
And that was a problem for her?
That was a big problem for her.
I guess as far as this tray tape, did you perceive it as a weapon?
Most definitely. I got hit. I almost knocked out with it. Of course, I thought it was a weapon. Of course.
And I think you told the members of the jury you were worried that she was going to hit you in the face with it.
Most definitely.
And that's why you turned.
That's exactly why I turned.
One moment, Charlie. Judge, may I publish, state 16?
Yeah.
All right, thank you.
Oh, let me get it.
I'm sorry.
No, you're fine, I just need to get it turned on.
I did, here it goes. Fine. It's on over here, Judge, it's not on TV.
There we go.
Thank you. And just real briefly, as far as you heard your mom testify about, were y'all in between the cars at some point?
Me and my mother?
No, you and Amber.
Yes.
All right, and that tray table we keep talking about is the tray table we see right here, right?
This is right there, sir.
All right? And as far as when the commotion initially took place, were y'all inside the garage?
Yes.
All right. Did you eventually end up out in this area? Out behind this vehicle?
Yes, sir, maybe just a little more to the other side.
Okay. And where was the gun at?
It was to the right of the vehicle.
Okay. Was it on a cabinet or something?
Yes, sir, it was on the ship.
All right. After the shooting, what did you do with the gun?
I put it on top of the car.
And did you tell the police that?
Yes.
Um, did you try to provide aid to Ms. Brown?
Yes.
Did your mom try to provide aid to her?
She was scared of her, yes.
Okay. Judge, I'll pass the witness. Thank you, Ms. Robinson.
You're welcome, sir.
Cross-examination.
Thank you, Your Honor. Mr. Robertson, I want to ask you a couple questions about what you just testified to, okay?
Yes.
Now, you're testifying because you said you want the jury to hear your side of the story, isn't that right?
Most definitely.
Now, we're hearing your side. Amber doesn't get to tell her side of the story, does she?
No, ma'am.
You voluntarily that night started telling police about what happened of your own accord, right?
Yes.
Nobody influenced you on what to say. You were just talking, right?
Yes, ma'am.
And the first thing out of your mouth, the first thing was, this lady was touching on my mom, right?
Yes.
And you've been here this entire trial, and you heard your mom testify, right?
Yes.
And you heard her say that Amber never got physical with her, correct?
Yes.
Now, you testified just now that you thought Amber might have been physical with your mom when they were in their room, correct?
Yes.
But you testified that the times that you saw Amber and the times you saw your mom, you never saw them being physical together, did you?
No, ma'am.
And so at the time of this shooting, you had never seen any kind of altercation physically between Amber and your mom at the time of the shooting, correct?
No, ma'am.
So there is no protection or defense of your mom at that point that requires deadly force, correct?
No, ma'am.
So the very first thing you told police wasn't in fact true. And you didn't just say that once, did you? You told police multiple times that you shot because you were defending your mom specifically. Isn't that right?
Everything happened so fast on the body cam, so that day, it was just a rush.
Okay. Do you recall telling the police multiple times you were defending your mom?
I seen
Okay, so that would be a yes?
it. Yes.
And again, this wasn't in response to their questioning, this was you telling them your story, right?
Yes, ma'am.
Now, you did say that Amber put hands on you, and you told police that night, right?
Yes.
And you never one time mentioned a TV tray, did you?
No, ma'am.
You never once mentioned that she hit you over the head with it, correct?
No, ma'am.
You never once mentioned that she threw it at you, correct?
Correct.
You certainly didn't mention that she was repeatedly charging you with a TV tray, right?
Correct.
Now, on direct examination here, 4 years later, all we're talking about in this trial is a TV tray, isn't that right?
Yes, ma'am.
Almost every single witness has been questioned about this TV tray, correct?
Yes, ma'am.
Would you agree with me that this TV tray has now become a very important part of your defense?
Yes, ma'am.
And that is something that never once got mentioned to the police, isn't that right?
Not that day. Yes, ma'am, it was not.
Now, you said that you were so scared of this TV tray that you grabbed a gun to scare her off, correct?
Yes, ma'am, it was the closest thing to me. The closest object to me.
The
Yes.
closest object to you in that entire parked garage was the gun?
Right there on the right side of that car, yes, ma'am.
Okay. And you feared that she was gonna end your life with that TV tray, didn't you?
I felt she was just gonna constantly just beat me with the tray. I'm not gonna say necessarily in my life, but I was defending myself because she could have been in my life after the first hit.
Okay, but your testimony is that she had in fact thrown a TV tray at you, right?
Yes.
Okay. And you're testifying that you were not in fear of your life.
I was.
Just that well, you just said that you weren't. You said that you were scared she would hurt you with it, but not that she would kill you with it.
Well, of course I was in fear of my life. I mean, if you get hurt, you're in fear of your life, I would think.
I'm asking you, were you
Yes.
afraid that she was going to kill you with that TV tray?
Yes.
Okay. And so, to stop her, you had to pull out a gun, and you said that you fired a warning shot, correct?
Yes, ma'am.
Where were you when you fired a warning shot?
Right there on the side of that car.
On the side of the car?
Yes.
Where on the side of the car?
I can't necessarily remember.
Can't remember that?
I don't know.
Where were you when you say that you started twisting your body shooting?
Close in the garage, but I can't remember too much either. I just know I was close
Can't
to the
remember that
garage.
either. So, let me ask you this. You said you fired off a warning shot and she kept charging at you, is that right?
When I fired up the one shot, she wasn't scared. She lifted up the tray and she charged towards me.
And I'm trying to understand your body. Were you moving, trying to run away from her as she is charging you, or are you
When
just
she
standing
jumped
still?
in, I turned around, ran, and let out some shots as I turned around.
Okay, you're saying that you turned around and ran, and then you started shooting her?
Well, technically, I turned around and just started shooting because she was getting closer. I was scared for my life.
She was getting closer. So, between the warning shot and the other shots that you fired, you had moved a bit.
Yes, ma'am.
Okay.
Not too much, though. It's not that much space in the garage.
Not too much, though. And where was Ambra when you shot?
She had to be right there, close to me, like right in front of me before I turned around. I couldn't see her after I turned around. I couldn't see her.
You couldn't see her.
No. I wasn't.
Don't know where she was.
When I turned around, no. When I turned around, I couldn't see her.
So your testimony is that you turned around and you started blindly shooting into the garage when you didn't know where Amber was.
No. Amber had lifted up the tray and she was coming after me. I turned around and fired out of fear of my life. After the warning shot, she wasn't scared.
I understand that. But when you turned your back and started shooting, you didn't know where Amber was?
I didn't.
So, how did you know that she was coming at you with a TV tray if you didn't know where she was?
That was before I turned around, no.
Okay, and so when you turned around and started shooting at her, where was she?
She had to be maybe behind me, maybe running away. I don't know.
Maybe running away? Is that what you just said?
I just wasn't looking at her, ma'am, so I can't really tell you. When I
Okay,
said,
so when you start shooting at her, she maybe was running away? Is that what you just testified to?
I testified to saying out of fear of my life, when I turned around and fired the gun, I just heard her say she was shot. I'd never seen where I shot her. I didn't even know she was shot.
And to be very clear about the jury, because there was some questioning about this with some earlier witnesses, Amber didn't grab the gun. You grabbed the gun, correct?
Yes, ma'am.
Okay. You are the one who brought a gun into the situation, correct?
Yes, ma'am.
You pulled the gun and you pulled the trigger, correct?
Yes, ma'am.
Not once, not twice, 3 times, ultimately, correct?
I don't know. I mean,
Well, you were sitting here in the trial, were you
Yes.
not? Did you hear the officers testify and the crime scene analyst testify that they collected 3 fired cartridge
yes,
cases?
I seen that. Yes, ma'am.
Okay, so you fired at least 3 times, correct?
Yes, ma'am. It had to be.
Okay. And you sat here during the medical examiner's testimony, correct?
Yes, ma'am.
And so you are aware that you shot her
Yes, ma'am.
post arterial, meaning from behind, correct?
Yes.
And your testimony is you don't know where she was. She could have been running away. And that is consistent with her being shot from behind, correct?
I don't understand the question. Say it one more time.
Your testimony is that when you turned around and started shooting, you don't know where she was. You said maybe she was coming at you, maybe she was running away.
That's exactly what I'm saying. Yes, ma'am.
Okay.
But I knew.
That would be consistent with being shot from behind, correct?
I don't know, because when I seen her, she was coming towards me.
You don't know.
When I seen her, she was coming towards me.
You were able to answer all of your defense counsel's questions well, but on cross-examination now, you can't remember things and you don't know how to answer the questions. Where was Ambra when you shot her?
After I shot her, she was on the ground. Ma'am.
Where was Amber when you shot her?
On the ground.
Where was she when you pulled the trigger?
On the ground.
She was on the ground when you pulled the trigger?
I'm sure I didn't see her. When I turned around, when I was scared out of fear, I shot her, and I just heard her say, "I'm shot."
You just testified, and I'm wrapping it up, you just testified that you didn't see her, she might have been on the ground when you shot her, correct?
No, when I shot her, she might have not been on the ground. She wasn't on the ground. No, when I shot her, she had to be coming towards me.
Well, you
Or
just
something.
testified you just said that she was on the ground. I said, when you pulled the trigger, where was she? And you said, on the ground. You just said that.
Okay, but
But you want to change that now? Do you want to amend that?
when I pulled the trigger, I don't know where she was.
Okay.
But after I pulled the trigger, she was on the ground.
But you would agree with me that if she wasn't charging at you, then using a firearm would not be immediately necessary, correct?
If she didn't have the trade charging at me, using a firearm would never been necessary. But after being dazed in my head, I did not want to take another blow to the head with the tray. I didn't want to take a couple more blows at all.
You were mad, weren't you?
I was scared.
Well, you told officers that you were heated, correct?
I don't remember that, to be honest with you.
Okay. Do you recall seeing your body cam?
Yes.
Do you recall telling the officers, me and her both got heated? And I see you shaking your head, but for the record, you have to answer out loud.
Oh, I don't remember that.
Okay. just to refresh your recollection, do you remember saying, first, this lady was touching on my mom, sir?
Yes, I remember saying that back in this one.
She came home to my mom and she was arguing, sir. Do you remember that?
Yes,
They came home and she was arguing. Stuff got physical, correct?
yes,
She said some words, me and her both got heated.
yes, okay, now I remember.
Okay.
Yes, ma'am.
She put her hands on me, so I grabbed my mom's gun.
Yes, I remember saying that.
I hit her a couple of times, and she kept charging me, sir.
Yes, I remember saying that too.
When you said, were you hitting her with your hands or with the gun?
The situation happened so fast that really wasn't
You don't remember?
the truth, to be honest. I don't want to say it, so like,
He said, I cannot lie, I shot her one time in the leg. Correct?
I said that yes.
She got into it with my mom, she physically kept touching her, and I had to defend her, my mom.
Yes,
We'll pass witness.
And you redirect.
Just real briefly, Mr. Robinson,
yes,
when
sir.
you said you turned your head to keep from getting hit in the face with that tray.
Most definitely,
So that's why you don't know exactly where she was.
most definitely.
But when you turned your head to keep from getting hit, she's right in front of you, isn't she?
Yes, sir.
And may I approach, Judge?
You may.
How far away from you with that tray table is, you tell me when to stop.
Right now.
Okay. And she's making you believe she's gonna hit you with the tray table.
Most definitely, yes, sir.
And think you testified you were afraid she's gonna hit you in the face.
Yes.
And based on that, what did you do?
I did off a warning shot.
All right. After that, was she still in front of you?
Yes, she didn't care.
All right. Did she still have the tray table?
Yes.
Based on that, when did you actually raise the gun?
When I seen her lift the tray up and she was taking steps forward, that's when I turned around.
Okay.
And just closed my eyes.
When you say you turned around, you turned to keep from getting hit?
Yes, sir.
All right. So as far as what she's doing or where she is at that time, is that what you're talking about? You don't know?
Exactly. Yes, sir.
But you do know you shot her in the legs. From the autopsy reports, right?
Yes.
At the time of the shooting, you didn't know.
At the time, I didn't know.
But from the autopsy report, from what the ME says, you know you shot her twice.
Most definitely,
But
yes.
what her position was at the time she was actually shot, you don't know because your head was turned.
Exactly.
Is
Yes,
that what
sir.
you're telling members of the jury?
Yes, sir.
And they're saying you never said anything about the tray table. In fact, you told the police things got physical, didn't you?
Yes.
And is that what you were referring to?
Yes.
Judge, I'll pass it with
And you recross.
Very briefly, if I
You
may.
bet.
Okay, so, to be very clear, it is your testimony that Amber was swinging the tray table at you at the moment that you turned and started pulling the trigger, correct?
She was charging me with the tray, yes.
No. She was charging at you or?
Swinging,
Which one is it?
yes.
Which one?
She lifted the tray up and she came towards me. She took a step. Yes, she took 2 steps towards me.
She took 2 steps toward you?
Maybe a step or 2, I don't remember.
I'm talking about the moment that you turned and fired the weapon.
Well, I couldn't see her when I turned and fired the weapon.
Okay. So you don't know when you fired the weapon, the moment you were using deadly force, you don't know what she was doing.
I was scared.
Is that a no?
No.
We'll pass it.
But when you fired because you felt it was necessary to protect yourself.
Exactly.
Because she had that tray table.
Most definitely.
That's all I have, Judge.
Nothing further?
Nothing further, Your Honor.
All right, Mr. Robertson, you may return to your seat. Please watch your step getting down to the witness stand.
Thank
Thank you. Call your next witness.
One moment, Judge.
Certainly.
Your Honor, ladies and gentlemen, the defense will rest.
All right, may I see the attorneys? right, ladies and gentlemen, I'm gonna send you back to the jury room for at most a 10-minute break.
All rise.
You may be seated. I know Mr. Harris said no, any additions to
No,
the charge, anything.
No, ma'am.
I do think that, I do believe that we had an objection to, the apparent danger language, starting on page, 5.
Okay.
And I believe we have, case law too, but I need to
Okay.
grab that from the printer if I can.
Sure.
No, that's what we used to use.
I'm sorry, Judge, we still need to print it, we're printing it right now.
No problem. I'm happy to take a look and read what you have and.
I believe it was from, when a person on page 5 through indictment instruction on page 6.
Okay. Mr. Worley, are
Yes,
you
ma'am.
working on the charge issue with Ms. Mitchell?
Yes, ma'am. I've actually, when it was,
Okay. So on page 5, do you think that it should not include the, third line from the bottom that starts with, "It is not necessary that there be an actual attack or attempted attack, as a person has a right to defend his life from an apparent danger as fully and to the same extent that he would have had the danger been real, provided that he acted upon a reasonable apprehension of danger as it appeared to him from his standpoint at the time, et cetera, et cetera."
yes, ma'am. In
Okay.
fact, I was looking at basically the, I guess, last 3 paragraphs.
Okay,
Because it's all kind of one apparent danger
Yeah.
instruction. The only other thing, and I'm about to print up what I've
Okay.
got here on that. The only other thing that I noticed was, hold on a second.
okay. I just wanted to, okay, so you don't think apparent danger,
Yes, ma'am.
applies?
Yes, well, I don't think that, I think apparent danger is not statutory, and as such, I think that it should not be included in the jury instruction, I believe it. And what I'm gonna send you basically talks about that
Okay.
only things in statute, let me print this up. And then on page 4, the only other thing that I noticed on page 4 was there's an "and" after subsection 1, and there's not an "and" in the statute. The only "and" comes after between subsections 2 and 3.
Okay,
I worry that the way that that's written, it makes it look like they have to be, in order for the person to get self-defense, that the jury would have to believe that they were trying to enter a habitation or trying to remove someone from a habitation or or attempting to commit one of the offenses in Part C. When I think what the statute is saying is that that's number one way, and then 2 and 3 are the other way.
Okay. Yeah, I didn't have a self-defense charge, so I asked Drew McKinney to draft it for me from the staff attorney's office, and that's what he sent me. Actually,
Can I approach, Judge?
yeah, absolutely. Just if you have it in case, if you could share it with the defense as well.
Yes, ma'am, I'll print it out.
Okay. You want me to read the Walters case?
The first one, it just talks about that only things that are statutory should be in the charge, and the second one deals more specifically with apparent danger. The first one is a Court of Criminal Appeals case, the second one, I believe, is a
Okay.
Dallas Court of Appeals case.
Okay. So, but you want me to, it starts with Walters or up here?
I'm sorry,
Yeah.
Walters is the citation for the first part.
Ah, okay.
And then below there, it actually starts with 3 jury instruction, because that was the place in the case.
Okay. I have the most recent, criminal jury instruction manual, so I'll go back and take a look at it.
Okay.
Okay.
I could email it too, I have a copy of the self-defense for myself.
Does it use yours?
Certainly. So for those of you that are law students, cases are overturned most often on what? Court's instruction. That's why we're spending so much time on it. If I get these instructions wrong, that's right. That's how cases are most often overturned. The court's instructions to the jury were somehow wrong. Did you have anything else you all wanted me to look at?
That was the only thing I saw, Judge.
Okay. Let me go back here and take a look, and I'll give Drew a call as
Yes,
well
ma'am.
after I read this and get his opinion. Okay, so I'll be back there. Don't get up. Thank you.
It's There you go. It looked like your hotspot at home. Yeah, just the service. It might still sing though. Go back to the is it sitting in the outbox? See if you can airdrop it, you airdrop it to me.
Oh, yeah. It's just a word document.
File and not before the presentation. It should be on the sheet. And what was the
That's James and Scott.
oh man, like especially now that it's like ready, man, like this thing can save a couple times. That's so basically, yeah, like last minute stuff you need done. Bust it out. There we go. Joy. No. If anything happens, take my number down. Something happens, I'm gonna shoot you a text.
You're doing good, man. I'm proud of you. Yeah. They can't do
682 217 Shoot me a text right here. Like I said, honestly, like 10, 15 minutes. Depending on the liberation or I'll let you know if anything pops up.
Thank you. The people over there. People over there. undivided. See, I don't go to it, it's right on the corner. Get up on. Y'all got Pappy on here?
Let me see if he in Ox too.
Be what?
He in Ox too.
Okay, we'll do that.
No.
Realize.
Yeah.
Someone has the money.
You were.
Or during Trump.
And you looked up at me. What he said.
And I looked back, I didn't particularly look at you, I didn't know who it was.
Oh, okay. I'm
I
sorry.
heard something.
It's all these holidays.
It wasn't you particularly during it.
I don't know if I eat food over there.
They started to like a lot of bad stuff.
I don't know her.
It's McDonald's.
Yeah. I'd be all right.
But you know, their meat may be a little different.
Yeah, it's a lot different.
It ain't all.
You cute, man.
It ain't all.
Hanging up out there. I don't know if that's that. That's all bacteria.
If they go to McDonald's chain, they have a certain amount of American beef, and maybe like 80% and 20% something else. So, mostly ox. Ox is a cow, I think.
I'm just weird.
I ain't know what oxtail.
I feel good meat.
How about rate the living down. You only need like $1,000 you can live if you can. $1,000 a month. And you can live off your you have a maid. I believe it's my partner. Because I used to work on DVD. He's just like one of the man with so much money. 800 credits. Nothing. He ain't got no bills except for insurance. He don't smoke, he don't drink. And he's thinking about moving to Texas. Without his house. No children, nothing else. That's my wife.
America. United States, I'm sorry. One of Thailand's insects right through your nose.
Wait, that's true. They do. California's over there.
Yeah.
Tie you up.
Yeah.
So just, well, oh.
Hang on, Captain. Hang on 1 minute. Hang on. Okay.
A, and this is the most bizarre thing to hear. She's in her head that you said two. So she says he can take one. You ace. He's already done one, that was clean. I got it. But I was like, well, it says here. And then you A, I want to get crosswise. She does not want to get crosswise with you. And I'm like, okay, I'll. He's down there ready, and I'm like, you know why we need to do this? I'm gonna give him like a star on this. I'm just gonna dismiss it. I'm sorry to bother you. No, but she was but she was excited. She
You don't see her when she's hanging.
I know.
Thank you for doing that.
Court conflict.
Oh, man.
It's gonna put a dent in what I'm trying to do, man. Everybody can't be attorneys.
Ooh, yeah.
So, you know, I'm trying to get my house, so I just got approved for like $6,000. Go give me some classes. Wash and dry and refrigerate that. It's great. You know, pay back 6 months, they pay it out. But don't do it till after you get the house. Try to do it before you get the house. The house is brown. Well, lay back on the ground. Look at that. Hang on 1 minute. Hang on 1 minute.
Yes, we'll go back on the record outside the presence and hearing of the jury. If the state could describe your objections to the jury charge as it is written right now.
Yes, ma'am. I believe that the paragraphs beginning on page 5, the very last paragraph on page 5, and then continuing through the end of the next 2 paragraphs, right above where it says indictment instruction. I believe that this, according to the Court of Criminal Appeals and according to the Dallas Court of Appeals, would be an impermissible comment on the facts by the court. I believe that according to Walters v. State, which I provided to the Court of Defense, that according to the Court of Criminal Appeals in 2007, the only thing that should be in the court's charge is something that is authorized by statute. I don't believe that the apparent danger language is included in a statute. And then the other case that I would cite is the Ryder v. State case. Again, that's out of Dallas from 2022. That case talks about the fact that while it is apparent danger is something that the jury needs to be made aware of, that can be done by the court giving proper instructions with regards to self-defense and the term reasonable belief. As long as it indicates that the person is justified in using a deadly force against another. Let me see, let me get the exact wording. Justified if you reasonably believe that the deceased was using or attempting to use unlawful deadly force against the defendant, and that you have a correctly defined reasonable belief, which we do in this charge. Reasonable belief here is, in the charge, is defined as a belief that would be held by an ordinary and prudent person in the same circumstances as a defendant. As long as those things are included in the court's general charge, then anything else is unnecessary and would potentially be a comment on the way the evidence by the court.
And what says the defense to that objection to the court's charge?
Your Honor, not necessarily an objection, but we emailed you some jury instructions. The emails in Mendoza, and it's pretty much the how the practice, straight out the practice manual, and has case law and everything up underneath it.
All right, Mr. Worley, I think those cases, that case can be distinguished as those were cases that did not include apparent danger, and that was the court's rationale in stating that in those cases, an instruction regarding apparent danger was not necessary because there was the definition of reasonable belief included.
Correct, and that's what I'm saying here, is that we have that in here, and as long as it's in here, there shouldn't be any necessity for any further instruction on the matter.
All right. And Mr. Mendoza, you're saying you want apparent danger included?
Yes, we do, Judge.
All right. Mr. Harris, thank you. Okay. And looking at the pattern jury charges, I do note that the state had also requested on page 4 of the current jury charge that the and be changed to an or.
I don't think an and or an or is in the statute. I think that it's just semicolon 2.
I disagree. This
I'm
tracks.
just looking at the statute itself.
Yes, this does track pattern jury charges. The and is provoking the difficulty. You don't get self-defense if you provoke the difficulty. So that's why the and is there. So I am overruling your request to remove that and, because I do think it applies and it also tracks pattern jury charges. Now, it is not any error to include apparent danger. It is up to the court based on the facts. And in this case, the testimony was from the defendant that he had been struck by a wooden TV tray wielded by the complainant once, and that he then perceived the wooden TV tray being wielded a second time as a threat to his life, and then shot the victim because of it. Since a wooden TV tray, in the way it was designed, was used to be used as a tray and not any kind of weapon, and in the manner of its use, it's supposed to be used for putting things on it and not in eating. I actually think this is a case that apparent danger applies, since that is the testimony, that he believed that this TV tray was capable of inflicting death upon him. So I am going to leave it in. So your objection is to that portion of the jury charges overruled. Are there any other additions or deletions to the charge? Okay.
Nothing to say, Judge.
Not from the defense, Judge.
All right, then we will line them up, and I'm gonna go grab my water. But you don't have to say that, I'll be right back. Okay, that sounds good, okay. We're ready, Mr. Sadler.
All right.
All right, you may be seated. The defense having rested, does the state close?
Yes, Your Honor.
And does the defense close?
We do, Your Honor.
All right, ladies and gentlemen of the jury, you've now heard all the evidence that you are going to hear in the case up to this point. We have prepared, the court has prepared the court's charge to the jury. This contains all of the law that you are to apply to the evidence in this case. I will now read this to you, and then we will have arguments of counsel. You do not have to memorize what I'm reading to you. This jury charge will go back to the jury room with you. Court's charge to the jury. Members of the jury, the defendant, Brad Maximus Robertson, has been charged by indictment with the felony offense of murder alleged to have been committed on or about the 13th day of June 2020 in Dallas County, Texas. To this charge, the defendant has entered a plea of not guilty. Offense definitions. Our law provides that a person commits the offense of murder if he intentionally or knowingly causes the death of an individual, or if he intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. Term definitions. An act means a bodily movement, whether voluntary or involuntarily, and includes speech. Person means an individual. Individual means a human being who is alive. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or a protracted loss or impairment of the function of any bodily member or organ. Mental state definitions. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Application of the law to the evidence. Now, if you find from the evidence beyond a reasonable doubt that on or about the 13th day of June, 2020, in Dallas County, Texas, the defendant, Brad Maximus Robertson, did unlawfully, then and there, intentionally or knowingly caused the death of Ambra Shante Brown, an individual, hereinafter called deceased, by shooting deceased with a firearm, a deadly weapon, or if you find from the evidence beyond a reasonable doubt that on the 13th day of June 2020 in Dallas County, Texas, the defendant, Brad Maximus Robertson, with intent to cause serious bodily injury to Ambra Shante Brown, did unlawfully, then and there, commit an act clearly dangerous to human life, to wit, by shooting deceased with a firearm, a deadly weapon, and did thereby cause the death of Ambra Shante Brown, an individual, then you will find the defendant guilty as charged in the indictment. If you do not so find, if you do not so believe, or if you have a reasonable doubt thereof, you will acquit, you will acquit the defendant and say by your verdict, not guilty. If you do not so find the defendant guilty of the offense of murder as charged herein, you will next go on to consider applicable statutory defense. Self-defense instruction. Under our law, a person is justified in using force against another in self-defense when and to the degree he reasonably believes the force is immediately necessary to protect himself against another's use or attempted use of unlawful force. The use of force against another is not justified, 1, in response to verbal provocation alone, or 2, if the actor provoked the other's use or attempted use of unlawful force, unless A, the actor abandons the encounter or clearly communicates to the other his intent to do so, reasonably believing he cannot safely abandon the encounter, and B, the other nevertheless continues or attempts to use unlawful force against the actor. A person is justified in using deadly force against another if he would be justified in using force against the other in the first place, as set out above, and when he reasonably believes that such deadly force is immediately necessary to protect himself against the other person's use or attempted use of unlawful deadly force, or to prevent the other's imminent commission of aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery. The term reasonable belief as used herein means a belief that would be held by an ordinary and prudent person in the same circumstances as the defendant. The term deadly force as used herein means force that is intended or known by the person using it to cause, or in the manner of its use or intended use is capable of causing death or serious bodily injury. The defendant's belief that deadly force was immediately necessary is presumed to be reasonable if the defendant, 1, knew or had a reason to believe that the person or persons against whom deadly force was used, A, unlawfully or with force entered or was attempting to enter unlawfully and with force the defendant's occupied habitation, vehicle, or place of business or employment, or B, unlawfully and with force removed or was attempting to remove unlawfully and with force the defendant from the defendant's habitation, vehicle, or place of business or employment, or C, was committing or attempting to commit aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery, and 2, the defendant did not provoke the person or persons against whom the deadly force was used, and 3, the defendant was not otherwise engaged in criminal activity other than a Class C misdemeanor that is a violation of the law or ordinance regulating traffic at the time the force was used. This presumption applies unless the state proves beyond a reasonable doubt that the facts giving rise to this presumption as listed do not exist. If the state fails to prove beyond a reasonable doubt that the facts giving rise to the presumption do not exist, you must find that the presumption exists. Even though you may find that the presumption does not exist, the state must prove beyond a reasonable doubt each of the elements of the offense charged. If you have a reasonable doubt as to whether the presumed facts exist, the presumption applies, and you must consider the presumed fact to exist. A person who has a right to be present at a location where the deadly force is used, who has not provoked the person against whom the deadly force is used, and who is not engaged in criminal activity at the time the deadly force is used, is not required to retreat before using deadly force to defend himself. If you find from the evidence that the defendant was such a person, or if you have a reasonable doubt thereof, you may not consider whether the defendant failed to retreat in determining whether the defendant reasonably believed that the use of deadly force was necessary. When a person is attacked with unlawful deadly force, or he reasonably believes that he is under attack or attempted attack with unlawful deadly force by one or more persons, and there is created in the mind of such person a reasonable expectation of fear of death or serious bodily injury to himself at the hands of such attacker or attackers, then the law excuses or justifies such a person in resorting to deadly force by any means at his command to the degree that he reasonably believes, viewed from his standpoint at the time, to protect himself from such attack or attempted attack. It is not necessary that there be an actual attack or attempted attack, as a person has a right to defend his life from apparent danger as fully and to the same extent as he would had the danger been real, provided that he acted upon a reasonable apprehension of danger, as it appeared to him from his standpoint at the time, and that he reasonably believed such deadly force was immediately necessary to protect himself against the attackers or attackers' attempted use of unlawful deadly force. In determining the existence of real or apparent danger, you should consider all of the facts and circumstances in evidence before you, all relevant facts and circumstances surrounding the use of deadly force, if any, the previously relationship existing between the defendant and the alleged injured party, or the other person or persons with the alleged injured party, together with all of the relevant facts and circumstances going to show the condition of the mind of the defendant at the time of the alleged offense, including any and all threats previously communicated to the defendant from the alleged injured party or the other person or persons with the alleged injured party. In considering such circumstances, you should place yourselves in the defendant's position at the time and view them from his standpoint alone. Now, bearing in mind the foregoing definitions and instructions, if you believe from the evidence beyond a reasonable doubt that the defendant is guilty of murder as defined in this charge, but you further find from the evidence, or have a reasonable doubt thereof, that the defendant reasonably believed that he was under attack or attempted attack with unlawful deadly force from Amber Shante Brown, and that the defendant reasonably believed, as viewed from his standpoint, that such deadly force, that such deadly force as he used was immediately necessary to protect himself against such attack or attempted attack, and so believing he shot the deceased with a firearm, a deadly weapon, then you shall acquit the defendant and say by your verdict, not guilty. Indictment instruction. An indictment is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence of guilt, nor can it be considered by you in passing upon the question of guilt of the defendant. The fact that a person has been arrested, confined, indicted for, or otherwise charged with an offense does not give rise to any inference of guilt in the trial. Presumption of innocence instruction. All persons are presumed to be innocent. No person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after a careful and impartial consideration of all the evidence in the case. You are instructed that jurors must be able and willing to make careful and impartial decisions that are not based on bias or prejudice. Do not let any personal bias, prejudice, sympathy, or resentment on your part, or any such personal emotion on your part, enter your deliberations or affect your verdict in this case. All persons deserve fair treatment and equal justice under the law, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You must set aside your own personal biases and prejudices during your deliberations and base your verdict on the evidence. Decisions based, either wholly or in part, on unfair stereotypes have no place in a criminal trial and will taint any verdict which is not based solely on the evidence and these instructions. Burden of proof instruction. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. The burden of proof in all criminal cases rests upon the state throughout the trial and never shifts to the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Evidentiary instructions. You are instructed that if there is any evidence before you in the case regarding the defendants having committed any having committed any offense other than the offense alleged in the indictment in this case, you cannot consider said evidence for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such other offenses, if any. Even then, you may only consider the same in determining the state of mind of the defendant, motive, opportunity, intent, preparation, plan, knowledge, intent, or absence of mistake or accident of the defendant, if any, in connection with the offense alleged against him in this indictment. At times throughout the trial, the court has been called upon to pass on the question of whether or not certain offered evidence might be properly admitted. You are not to concern yourself with the reasons for such rulings and are not to draw inferences from them. Whether offered evidence is admissible is purely a question of law. In admitting evidence to which an objection is made, the court neither determines what weight to be given such testimony nor passes upon any credibility of the witnesses. As to any offered evidence that has been rejected by the court, you, of course, must not consider the same. As to any questions to which an objection was sustained, you must not conjecture as to what the answer might have been or as to the reason for the objection. You are instructed that you are not to allow yourselves to be influenced in any degree whatsoever by what you may think or surmise the opinion of the court to be. The court has no right by any word or any act to indicate any opinion respecting any matter of fact involved in this case, nor to indicate any desire respecting its outcome. The court has not intended to express any opinion upon any matter of fact in this case, and if you have observed anything that you have or may interpret as the court's opinion upon any matter of fact in this case, you must wholly disregard it. You are instructed that you may consider all relevant facts and circumstances surrounding the death, if any, and the previous relationship existing between the accused and the deceased, together with all relevant facts and circumstances going to show the condition of the mind of the accused at the time of the offense, if any. Deliberation instructions. After you retire to the jury room, you should select one of your members as your presiding juror. It is his or her duty to preside at your deliberations, vote with you, and when you have unanimously agreed upon a verdict, to certify to your verdict by using the appropriate form attached hereto and signing the same as presiding juror. Your verdict must be unanimous and shall be arrived at by due deliberation and not by majority vote or any method of chance. It is only from the witness stand that the jury is permitted to receive evidence regarding the case, and no juror is permitted to communicate to any other juror anything he may have heard regarding the case from any source other than the witness stand. You are instructed that any statements of counsel made during the course of the trial or during argument not supported by the evidence, or statements of law made by counsel not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider or mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. If members of the jury disagree about the statement of any witness, the court reporter will read back to you certain testimony. The court will allow the court reporter to do this only if you submit a written request to the court signed by the presiding juror that states that members of the jury have a disagreement with a specific statement of a witness, 2, identifies the witness who made the statement, and 3, requests that the testimony be read back. The court will then have the court reporter read back only that part of the statement that the members of the jury disagree about. During your deliberations, you are also instructed that you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic devices such as a telephone, cell phone, smartphone, iPhone, or computer to access the internet or any internet service, or any text or instant messaging services, or enter any internet chat room, post on a written or video blog, or post on any social media applications such as Facebook, Snapchat, LinkedIn, YouTube, Instagram, TikTok, True Social, or X, which used to be Twitter, to communicate to anyone any information about this case or conduct any research about this case until the court accepts your verdict, if any. After you have retired to consider your verdict, no one has any authority to communicate with you except the bailiffs who have you in charge. You may communicate with this court in writing, signed by the presiding juror, through the bailiff who has you in charge. Do not attempt to talk to the bailiff, the attorneys, or the court considering any question you have. Your sole duty at this time is to determine the guilt or innocence of the defendant under the indictment in this cause and restrict your deliberations solely to the issue of guilt or innocence of the defendant. If you have a verdict or if you wish to have a break, turn on the red light and the bailiff will quickly respond. I lost my pen. Alright, this is signed by me, Nancy Mulder, presiding judge. Got an extra page. Alright, the last last page has the verdict forms that read, "We, the jury, unanimously find the defendant, Brad Maximus Robertson, guilty of murder as charged in the indictment," where the presiding juror has a place to sign and then print his or her name. Or, "We, the jury, unanimously find the defendant, Brad Maximus Robertson, not guilty," with a place for the presiding juror to again sign and then print his or her name. We will now have arguments of counsel. Will the state open?
Yes, Your Honor.
Would you like a warning of any amount of time used?
Can you tell me when I used 8 minutes, Judge?
Sure.
Ladies and gentlemen of the jury, thank you very much for your time. Thank you very much for your attention the last couple of days over the course of this trial. I talked to you a couple of days ago about the law, and that's what I'm mostly going to talk to you about again today. We talked about, well, you just got to listen to this long court's charge, another document written by lawyers, right? So I'm going to attempt to clear some things up as we go through this, okay? As we talked about, there are 2 different ways to prove up murder. That's in this charge. The defendant, on or about a certain date in Dallas County, Texas, intentionally or knowingly causes the death of an individual and the user exhibited a deadly weapon. Or the second way, they intend to cause serious bodily injury and they commit an act that's clearly dangerous to human life that causes the death of an individual and the user exhibited a deadly weapon. Well, folks, one thing I forgot to tell you on Monday, you don't have to agree about which one, okay? 6 of you may believe that it's the first way, 6 of you may believe it's the second way. That's okay, as long as all 12 of you are unanimous that one way or the other, that the defendant committed the murder, okay? And I'm going to tell you, folks, Judge, we spent a lot of time talking about this second way. This commits an act clearly dangerous to human life. Folks, I think we proved up the first way as well. One of those things there it says is that the defendant knowingly causes the death of an individual. Knowingly, as the judge just gave you, is defined as a person acts knowingly or with knowledge with respect to the result of his conduct when he's aware that his conduct is reasonably certain to cause the result. You all know, everybody in this courtroom knows, and Brad Robertson knows, that if you point a firearm at another human being and you pull the trigger, that's reasonably certain to cause their death. Okay? So it's not just a given that he didn't intentionally or knowingly cause the death of Amber Brown, even by the statement that he gave. He knew when he pulled that trigger that it was likely to cause the death, because that's what happens when you shoot people. But the second one intends to cause serious bodily injury, and we heard lots of people talk about that. Now, he says, and by the way, you can have more than one intent at the same time, right? He says he intended to back her off. Okay, well that doesn't negate the vehicle that he used in order to try and back her off, if that's truly what he was trying to do. He used a firearm. He shot her with a firearm, all right? That is, number one, obviously an act clearly dangerous to human life, but also he intended to back her up by causing serious bodily injury. He intended to shoot her with a firearm, all right? And you can glean that intent from his actions. No, he didn't get up there and say, I intended to cause serious bodily injury. People often don't admit to the crimes that they commit when they get up on the stand. It doesn't mean that you can't look at the facts and determine from those facts what their intent was. His intent was to shoot her. His intent was to cause serious bodily injury, all right? And he did commit an act clearly to human life, clearly dangerous to human life, and she did die as a result of those injuries. You heard that from Dr. Dyer yesterday. One of the things I want to talk about too is, you know, there's a long few paragraphs here where we talk about apparent danger. Okay, where there's several paragraphs that were read, and it talks about that if the person's being attacked and he thinks he's being attacked with deadly force, but maybe he's wrong about whether he's being attacked with deadly force, but you look at it from his circumstances. I want to point out what this what these paragraphs are really about, okay? They're in here and there's something that you should read and you should consider. But they talk about, in determining the existence of real or apparent danger, you should look at the previous relationship that existed between the defendant and the alleged injured party, including any and all threats previously communicated to the defendant from the alleged injured party. So what we're talking about here, what this is really about, is a situation where you have a person who is, for instance, a battered woman, okay, who has consistently been attacked by a certain person, and in this particular instance, maybe they had a reasonable apprehension given the circumstances, but they weren't actually being attacked, or it's not sure if they were actually being attacked, and they used deadly force to kill that person, okay? That's not what we're talking about here. That's not what happened here. There's really been no indication that that's what happened here. What happened here was that we had two people who, according to the defendant, according to his mother, have never had a relationship, a violent relationship between the two of them. That we had a bad night, and we had the defendant who made a very, very bad decision. He brought a gun into a fist fight. Now, we've heard a lot about the tray. I want to talk, let's real quickly move to the self-defense aspect. A person is justified in using force against another when and to the degree he reasonably believes the force is immediately necessary to protect himself. It's not justified in response to verbal provocation alone, and it's not justified if he provoked the other's use or attempted use of unlawful force. And he is only justified in using deadly force if he be justified in using force, and when and to the degree he reasonably believes the force is immediately necessary to protect himself against the other's use or attempted use of deadly force. Remember, we talked about that. You can only meet deadly force with deadly force. You can't be the first person to go to deadly force or to prevent the other's imminent commission of all these other crimes, which there's been no talk of any of that. No, this is purely about, was it immediately necessary for Brad Robertson to use deadly force at the moment that he used it? And he used it more than once. He shot her twice. Was it immediately necessary both times he pulled that trigger? And the answer to that is no. The answer to that is no. And how do we know? Well, you know, I don't think that Mr. Robertson ever told you the truth about what happened. I don't think that he told the full truth to the police that night, and I don't think that he told you the full truth here today in the courtroom. So how do we know what happened? Well, we glean from what we have heard from Mr. Robertson, but also from what we heard from his mother, Angela Abdul, and we look at what the physical evidence says, right? We look at the evidence that was collected there at the scene. We look at the evidence that the medical examiner brought you. We put that all together, and it gives us a more complete picture of what happened. What did he say at the time? This lady was touching on my mom, sir. That's the first thing he tells police as he's trying to justify what he's done. This lady was touching on my mom, sir. She came home to my mama. She was arguing, sir. They came home, and she was arguing. Stuff got physical. She said some words. Me and her both got heated. She put her hands on me, so I grabbed my mom's gun. She put her hands on me, so I grabbed my mom's gun. Why did you grab your gun? Why did you grab your mom's gun? Because she put her hands on me.
You've used 8 minutes, counsel.
So I grabbed my mom's gun. I hit her a couple of times, and she kept charging me, sir. I cannot lie, I shot her one time in the leg. That was it, sir. She got into it with my mom. She physically kept touching her, and I had to defend her, my mom. We know parts of what he said were not true, don't we? Because Angela Abdul, the one person who got up, she had no reason to lie. What a horrible, horrible position that woman was in. What a terrible situation she found herself in, having a woman that she loved killed by her son that she loves very much. What a terrible, terrible position that she had to be in to get up there and testify about what happened. And she told you that there was no physical confrontation, that there was no fight between her and Ambra, that there was nothing for Brad to protect her from. So we know that Brad was not telling the truth when he said that. And that's how you also know that this famous TV tray that we spent the entire trial talking about, that this TV tray was not the motivation for him to shoot her. All right? If she'd have pulled a gun on him, you think he would have said that? If she'd have pulled a knife on him, do you think he would have said that? But he's telling you today that this TV tray was what put him in fear of his life, but he never mentioned it. But it goes beyond that, because I have a feeling that the defense is probably going to give you lots of reasons why he might forget to mention the so-called deadly weapon that she was trying to use against him, that put him in such fear for his life that he had to shoot her, okay? I imagine he's going to have lots of reasons why he would forget to mention that. But it's not just about what he forgot to mention, it's what he did mention. Because he was trying to justify to the police why he did what he did. And what did he say? He said, "This lady was touching my mom, sir. She got into it with my mom. She physically kept touching her, and I had to defend her, my mom." So he's coming up with reasons to justify his actions that are not true, that we know are not true. If he had a real reason, like a TV tray, he would have said that. Instead, he's making up things that don't exist to try and justify his actions, when the truth is a lot easier, folks, and it's pretty easy to determine in this case that he got angry, that there was some kind of altercation between the two of them, that he got angry, and that he shot Amber, that he shot her in the legs. That's the simplest, most straightforward answer to what happened that night. And it fits, by the way, all of the evidence, all the physical evidence, all the medical evidence, and it fits with what he has said and with what Angie has said. The only weapon that he mentions is the one that he used to kill Amber Brown. And that's why he's guilty of murder.
Mr. Mulder, Mr. Harris.
Ladies and gentlemen, let me explain something to y'all. First and foremost, he was never interrogated by the police. What you saw in that video is him rambling after killing someone that he actually loves, after shooting someone that he actually loves, seeing her laying there in blood. He's rambling. The police are out there with their guns. You got all those police out there. He's rambling about what he thought he was doing, protecting his mom, and then eventually ended up protecting him. And the state knows, when he gets to the police station, like many people who were charged with murder, he invoked his fifth to talk to a lawyer. And then he tells his lawyer what happened. The police never asked him, "Oh, what physical stuff? What do you mean physical stuff?" They never specifically asked him, "What did she hit you with?" That wasn't an interrogation. He's rambling. He just shot a lady who's been like a mom to him because he thought she was being physical with his mom. That's what Miss Abdul told you. It may have sounded like that, but she never hit me. But I can understand why he thought she was being physical with me. He didn't provoke the difficulty. He goes in the garage to tell her, "Look, my 2-year-old is in here. Can y'all please calm it down? What's going on?" She's mad because he's there and her daughter ain't there. And she's hot about it. She don't have no control. And she's mad about it. And she wants control. She can't get it from Miss Abdul, so she takes it out on him. Throws the tray table at him. And ladies and gentlemen, whether they like it or not, we talk to you over and over. Anything can be used as a deadly weapon. In this case, the tray table was used as a deadly weapon. When she hit him in the head the first time, she throws it, hits him in the head, he tells you it almost knocks him. He's dazed. He's dazed. The mother comes out, breaks him up. He thinks it's over. Well, it's not over. It's not over. Because Amber's not finished. And they continue to get into it. And that's why I asked the mother specifically, when you went in the house, how long were you in the house? She said, at least a minute, maybe even 2 minutes. A lot can happen in a minute or 2 minutes. In fact, in this case, the evidence is a lot did happen. Because you know that they got back into the confrontation. The physical stuff, she got physical with me. What does that mean? Now let's talk about what he actually told you. Again, under him, when he's testifying, to the prosecutor, they're trying to trip him up. He's trying to explain to you that at the time she grabs the tray table again, he grabs the gun to scare her, not to kill her, to scare her. But that doesn't work. She's threatening him with the tray table. She hands the tray table. He fires a warning shot. And then he ends up firing 2 more shots. How do you know that's consistent? Because that's what the physical evidence shows. We know that 3 shell cases in that garage. She's only hit twice. Well, if he's shooting at her, why would she hit 3 times? Because he did fire a warning shot. Why? To keep her from hitting him with the tray table. Now, why does he not know that when he raised the gun, that's when she had to turn? That's what I was going over with the medical examiner. Those injuries are just consistent. He raises the gun to scare her. She's still coming. He raises the gun. He turns because he doesn't want to get what? Hit in the face. He doesn't want to get serious bodily injury. She doesn't have to knock his head off. She doesn't have to. If it was a baseball bat in that floor rather than that tray table, we wouldn't even. I mean, come on. That'd be easier for you to understand. But whether you're talking about a baseball bat, whether you're talking about a knife, whether you're talking about a gun, we're talking about a tray table that was used as a deadly weapon. And what do I mean by deadly weapon? Unlawful force. Unlawful force. All that's required for serious bodily injury is protracted loss or potential permanent injury. What does that mean? If I hit you in the face with a protractor, it breaks your nose. Hit you, it splits your orbital. The number of serious bodily injuries that you could sustain from someone hitting you in the head or in the face with a tray table. That's why his reaction was to turn. And it's a reasonable deduction from that, but when he turns, she sees the gun and she turns. He fires. Boom, boom. That's how she gets hit in the leg. But he's not trying to kill her. He's trying to keep her from hitting him with the tray table again. Unlawful force. He's entitled to use what he felt at the time could prevent her from inflicting unlawful force that could cause serious bodily injury or death. Use or attempted use, that's what the indictment says. That's what the jury charge says. That's why the parent danger and all that stuff is in there. Again, he didn't have to wait for her to hit him in the face with the tray. That's why he turned. Doesn't that make sense? He turns. What is he turning from? If he has a gun, why is he turning? And again, if he's shooting her, why don't you have 3 shots? It's because it happened exactly what he told you it happened. He's a 19-year-old kid rambling about him thinking he's protecting his mother. I get into it with Miss Brown. I'm trying to protect myself. It's physical stuff. That's what he's talking about. But I submit to you that, in regards to the specifics, what was the physical stuff? They never asked him that because that wasn't the setting for that. You do that back at the police station. He, again, like many people who are charged with a crime, invokes his fear. He says, I want to talk to a lawyer. This is serious. Y'all charging me with aggravated assault with a deadly weapon. Because that's what the charge was initially. It's only escalated after Miss Brown dies. And again, ladies and gentlemen, this is, I think he told you from the beginning, he wished he hadn't grabbed the gun. He's not happy he had to shoot her. He did what he felt that night in those early morning hours was immediately necessary to keep her from hitting him upside the head with that tray table and potentially inflicting serious bodily injury on him. That's what he did then, and that's what it is. I mean, it is tragic. It shouldn't have happened. But in regards to him provoking, he didn't provoke difficulty. He went out there to calm her down. She's the one who's amped up. She's the one on drugs, whether it's marijuana, fentanyl, if you want to believe what the examiner said, we know that she's acting like she's never acted before. That came from Ms. Brown, that came from from Ms. Abdul, and that came from Mr. Robinson. She's the aggressor out there. And ladies and gentlemen, I would submit to you that that's exactly what the evidence shows. And we didn't, if you look at, even if you recall the testimony, you can look at the photos. I think that it was the crime scene analyst even indicated that the tray table had some blood on it, all right? And I would just submit to you that that is consistent with the tray table being near Ms. Brown, just as he told you she had the tray table. Now, they make a big deal, well, was the tray table, we don't know where the tray table ended up after the immediate shooting because there's so much commotion. He comes back, they're trying to provide her aid, his son is there, they don't want to move her. The police, you see the police trampling in and out of there. We don't know what or where the tray table ended up after she dropped it. We do know that it's in that garage. And it's was used by Ms. Brown because that's what he told you. And I want to make sure we're clear that on each and every element of this offense, the state has to prove that Mr. Robinson committed this offense. They're talking about intentionally knowing. We keep bringing up the point that he did not intend to shoot her. I will remind you of the testimony of the medical examiner. She says a lot of people think that you can shoot somebody and they won't die, you know, or that it won't cause death. I mean, a lot of people thought that. He's telling you it was not my intent, not intentionally or knowingly, to cause her death that night. All I was doing was trying to keep her off me, trying to keep her from hitting me again with the tray table. That's it. Trying to keep her from harming me. That's why I grabbed the gun to scare her. That's why I grabbed the gun and I fired in the manner that I fired. Again, downward toward her legs to keep her from coming at me. That's what he told you. That's what I believe the evidence shows in this case. And I want to make sure we're also clear that we brought up self-defense. I told you from the beginning that this was not a who did it. It was all over the place about why he felt it was necessary, immediately necessary, to inflict the injuries that he inflicted on Ms. Brown. We've explained that. But the bottom line, ladies and gentlemen, is the state had the burden to prove beyond a reasonable doubt that it was not self-defense. They haven't done that. They haven't done that because it was self-defense. From his standpoint, from her actions against him, they haven't disproved self-defense. And that's because it did happen exactly the way Mr. Robinson told you. Now, Mr. Robinson, again, doesn't do this every day like we do. So yeah, these are great prosecutors, you know, work for the state of Texas, they're great at what they do. But if you really look at what he's telling you, oh, they're gonna say, well, he didn't know where she was. Well, he's telling you, I don't know where she is because I turned my head. I don't know, once I turned my head, I don't know what she did until I looked back. And then by that time she had fallen. But when he makes a decision to grab the gun, she has that tray table. When he makes a decision to fire the warning shot, she has that tray table. When he makes a decision to turn his head, he turns his head because she's about to hit him. And when he makes a decision to fire, he's firing because doing so in self-defense. That's what the evidence is. That's what the criminal evidence is. And we're going to ask that you find Mr. Robinson not guilty based on self-defense because he is not guilty. Thank you.
Thank you, Mr. Harris. Ms. Mitchell.
Thank you, Your Honor. May it please the court? Ladies and gentlemen, you have heard a lot from a lot of different people. And I want to make this as simple as possible. I'm not going to go through these because my co-counsel already did. The elements of murder, both ways. The first way, which my co-counsels have gone over, we've met every single one of those elements. I think actually defense counsel and I would probably agree that this is not a whodunit. All of the elements have been met. You can't get self-defense unless all of the elements are met. So there is no question that regardless of which way we're talking about murder, the elements have been met. Nobody in this room is questioning that. What is being questioned is self-defense. We know who did it. Was Brad Robertson justified in doing it? Okay? So that's the part of the analysis you guys come in on. It's not a question of whether he did it, it's was he justified in doing it? My co-counsel's gone over this again. But these are the 4 basic parts of self-defense. When and to the degree. That means, was it proportional? We talked a little bit about this in Mulder, but I can't be in a fist fight and pull out a knife. That's not proportional. My co-counsel said, you can't bring a gun to a fist fight. Why? It's not when and to the degree. That's not proportional. Okay? That he reasonably believes, in this case Mr. Robertson reasonably believes, or a reasonable person believes, a reasonable person who is in Mr. Robertson's situation. Okay? It's not Brad Robertson himself. We know what Brad Robertson thought. He shot the gun. You know what he thought. But it's what does a reasonable person believe is immediately necessary? Why do we all keep harping on this? Oh, is it immediately necessary? Because that is what the law says. In Mulder, you all were asked a lot about, oh, who's a gun owner, who's a gun. This is not about who's a gun owner and who's not. Responsible gun owners can understand that you don't pop off shots on people unless you have one specific intent. I believe some of us were asked, would you protect your loved ones? Would you protect your home? Absolutely. It's not what was happening here. To protect against unlawful deadly force. And I keep bringing this up. I keep bringing this TV tray up because actually it's the first time we're really getting to hear about it. And the most important part of self-defense, you must be able to meet the requirements, this framework of self-defense for every use of deadly force. So when you're talking about shooting off a gun 3 times, you better make sure that every time you shoot, those 4 elements can be met. Every time you shoot, it had to have been to the degree that you reasonably believe it was immediately necessary to protect against unlawful deadly force. So let's talk about why he said he did this. There's a lot of text on here. I put Brad Robertson's first story because during trial it evolved a bit, and we'll get to that. He says, Amber was beating Brad with her hands in a TV tray, such that he feared for his life. But we have in States 31, taken the night of the offense, Brad does not have one single mark on him. There's nothing on his head. I think defense counsel said, oh, well, if you were hit with a TV tray, that could give you a bloody nose. There is not one mark on this man. Ambra, if you look at her autopsy report, not only sustained the gunshot wounds, she also had 2 head injuries that Dr. Dyer said were acute, meaning occurring at the same time of her other injuries. Brad says he shot Amber 1 time in the leg. Well, the objective evidence is that there were 3 fired cartridge casings collected from the scene, and Amber was shot once in each leg from behind. Brad says Amber was charging him, so he had to shoot. Again, the entrance wounds to both of Amber's legs were from behind.
Judge, I'm gonna object as a misstatement of the evidence.
Overruled, closing argument, and the jury will remember the testimony as best they can.
Go look at the autopsy reports that have a chart and diagram where the entrance wounds and where the exit wounds are. Brad says Amber was physically assaulting his mother, so he had to shoot. Angela testified that that didn't happen. She'd never been physically assaulted. And when Brad testified, I specifically asked him, okay, well, all right, you thought that they were fighting in the room, but when you got in the garage, you didn't see them fighting, did you? And he said, no. I said, okay, so there was no immediate need then to defend your mother at that point, right? He said, yeah. Okay. So then, why did you tell the police that? Now, here's the thing. This is Brad's story, his first version. I threw the TV tray in there too. But from opening statement, defense has said, let's look at the objective evidence, the credible evidence. So let's do that. You know, they're saying, oh, well, I don't know where Amber was. I don't know where Amber was. The problem for the defense is that all of Brad's statements are exactly in contrast to all of the objective evidence. Not what comes from Brad, but all of the hard evidence that he can't change. When you're talking about where Amber was, you can look at these crime scene photos. You see the TV tray. That TV tray that had the blood on it, you know exactly where Amber was. The defendant may not have. I asked him about 4 different times, where was Amber? I don't know. Well, he certainly had all the answers and details when his lawyer was asking him. I was trying to ask him questions and it became, I don't remember, it happened so fast, I don't know. So I asked him probably 3 times, where was Amber? Where was she when you pulled the trigger? I was trying to be as specific as possible. I don't know. You know where she was. The problem for Brad is that the physical evidence doesn't lie. She was standing where that TV tray was because that's where the blood is. You know exactly where Amber was in that garage when she got shot. But you know what's interesting about that? Brad says she was coming at him. So he grabbed the gun from where? Over here. Amber was standing in the middle of the garage when she got shot. Brad got the gun over here. You know where the fired cartridge casings were? And that's when it ejects after the bullet's been fired? Over here. Brad went and got the gun and fired the gun over here. He came back. That's what the objective evidence shows. That's what Brad cannot get around. He can't do anything about those facts. So, the most important day of Brad's life is today. Brad got on the stand to testify about the most important event in his life. Couldn't remember much about it. Was certainly different than what he told the police. It's had 4 years now. It's been 4 years and not one time did this TV tray get brought up. As my co-counsel said, if somebody's charging you with a baseball bat, let's use defense counsel's hypothetical. A baseball, she's coming at me with a baseball bat. Okay, not one time did he mention a TV tray. She wasn't charging on me.
I'm gonna have to object at this time, that they're coming on my client's right to remain silent.
Well, your client did testify, so overruled.
Okay. Just want to make record.
When Brad Robertson spoke to the police, he never mentioned the TV tray. Until today. 4 years later. You know why? Because the things that he did say to the police don't give you self-defense. Brad saying, I don't know where Amber was. I don't know where Amber was when I pulled the trigger. At one point he said, running away. And I said, did you say running away? And then, oh, no. I don't know. Well, guess what? Running away is consistent with those injuries. Dr. Dyer testified that, and I stood up here, in heels balancing on one foot, that entrance wound and the exit wound, the direction of them, she would have had to have been in a motion walking or running or on the ground. And interestingly, Brad then said, I don't know, she was on the ground. When you are talking about self-defense, every single use of deadly force has to be justified. So when somebody's running away from you, it is no longer immediately necessary. When somebody's on the ground, it's no longer immediately necessary to shoot them. Self-defense does not apply in this case, whether you want to look at the objective evidence with the autopsy reports, whether you want to take half of Brad's statements for truth. So at this time, I am asking you all to find the defendant guilty, and I came up here yesterday and told you I would. I said, you're gonna hear about all this evidence, you're gonna hear the testimony, and you're gonna get to consider it, the 12 of you. And you really are considering, was he justified or not? He was not. He can't get around the objective evidence. And defense counsel has done a good job of saying, well, maybe possibly she could have been turning like this, or he could have been turning like this when he shot. We don't have to disprove every wild possible scenario that the universe could create. You see it in your jury charge. We don't have to prove his case beyond all possible doubt because there's no way. None of us were there. It's beyond what is reasonable. What is reasonable? Amber was mad at Angie. They got in a fight. Amber picked up the TV tray from the back of the garage and chunked it at him. And you see where it landed. And you see where she was standing over it. As Brad left, thought he was going back in the house. He grabbed the gun though, turned around and shot her. There is no question of who did it. There is no question that it was not justified. This was not self-defense. And so I'm standing up here like I told you I would, and I'm asking you all to find the defendant guilty of murder because we've proved both ways. Because that is what the objective evidence that Brad can't get around shows. And because you're not telling him something he doesn't already know.
All right, thank you, Ms. Mitchell. Ladies and gentlemen of the jury, you will now retire to the jury room to consider your verdict.
All right.
And for our alternate juror, you're gonna go get to sit in another jury room and just wait patiently by yourself. Mr. Tapper will show you. So, I guess I should have told them they can decide about lunch. I'm gonna tell them that they can decide if they wanna eat lunch now or deliberate for a little bit or whatever they wanna do. Thank you. Oh, y'all may be seated and, Mr. Harris, I just need your cell phone number in case, Knock it up, knock it up. Okay, they're gonna be at lunch until 1:05. All the lawyers are gone. Shoot. Second back.
Yep. Oh.
There's bee faces down there.